We do have an email question that's already come in tonight, and so if we can get that up, guys, we'll just jump right into that. Is there a time limit for when a person can sue another property owner for injuries that occurred while working on that person's property? Michael, now Ted, I'm going to assume this is Florida law.
Yes, we were going to assume that. And then, Michael, one of the first things we need to make sure and be clear about is just because you are on someone else's property and you are injured does not mean you automatically have a claim.
Right.
This says you were working on someone else's property, so in order for them to be liable, you need to establish that they were in some way negligent, which means they failed to use due care under the circumstances. There could be some issues potentially about a workers' comp claim, but typically if you're working for somebody else on their property, you're going to be an independent contractor,
right,
and so you're going to need to establish negligence. If we're assuming that there was something they did wrong, for example, they had a hole on the property they knew about and didn't tell you about it, didn't warn you about it, didn't remedy, and you fell in it and you injured yourself, the statute of limitations that you're looking at now is 2 years. Historically, Florida had been 4 years. And this past year, back in 2023, they changed the law on that now, and for anything that happens after, I believe it's early March of that year, is going to be a 2-year statute of limitations. So depending on the timing, right now there can be a difference.
Now, Ted, that's big because
it is
4
big.
years to 2 years. I'm assuming that Michael feels it if he's hurt because he's quantifying the word injuries here.
No.
But what about med pay? How does that work into this situation?
Well, there is the potential, another form of coverage that can be on homeowners policies, which is called medical payments coverage, which is a type of coverage that will pay irrespective of fault.
Right.
It is that kind of where you are the insurer of the premises under certain limitations, but typically if you have an injury that manifests and you get those bills paid, normally within, there's sometimes a limitation on that, sometimes that has to be paid within a year, just depends, it's specific to each policy. So even if there was not negligence, you possibly can recover under a medical payments provision under a homeowner's policy.
Now, assuming someone says, hey man, they paid me this medical payments coverage, they have to be liable. That's not always the case.
That's
not an admission of guilt or admission of fault, I should say.
And you won't look, you're not able to use it that way. There's actually evidentiary prohibitions against that under our evidence code that would not allow that to be admissible as some sort of admission of fault, because we want people to pay for medical treatment, we want people to get help, and we don't want them to not do that out of fear of some sort of concession. In any event, it's just not, as a practical matter, if they're required to pay it under the contract, it does not mean that they were negligent. They still could have been, it's just something you have to prove.
Now Ted, a quick question here would be, Michael obviously hasn't gone and gotten treatment. Well, at least I assume he hasn't. How is that different in an auto case?
Okay.
We have time limits in an auto case where somebody has to get treatment within a certain amount of time or they lose all benefits.
It can be that way, yes. And that's because of as many people have heard the term that Florida is a no-fault state. And I always like to say yes and no.
Right. Yes.
We are a no-fault state, but that does not necessarily mean what some people believe that it means. What it means is that in Florida, in an automobile accident, the legislature has made the decision that everyone will, in essence, be self-insured for the first $10,000 of any injuries. That is the personal injury protection, which is commonly referred to as your PIP benefits. And in order to maximize and to get the full benefit of that $10,000 in PIP benefits, you must seek and obtain treatment within 14 days of the accident. That needs to be, and they have to.
Now that's because it's on your own policy.
It's on your own policy.
Right.
Well, it's supposed to be on your own policy,
in a
subject to some exceptions. For
Right.
example, if you don't have auto insurance and you're in an accident as a passenger or as a pedestrian, you potentially qualify on either the vehicle that hits you or if you live with someone that has a policy. So even if you don't have your own policy, there still is likely to be PIP benefits available to you if you're in an auto accident. And it's important that you go seek that treatment or you lose that self-insurance for $10,000. It can be very detrimental.
You can't just go see anyone. There are certain providers that you have to get treatment from, and you have to be diagnosed with an emergency medical condition, right?
Right. Otherwise, you can be limited to $2,500 in coverage as opposed to the full $10,000
that you have paid for.
Right. And so you want to, as we tell people, our business is trying to make sure that you get whatever you're entitled to, and so that you know. I mean, information is power and it's key. You have to know what you have and what your options are, and we want to make sure first and foremost that you can get that treatment so that you can be back to as close as you were before the accident. You're never going to be exactly there, but we want to make sure that you get that treatment, and the first step is making sure that you have the benefits to get that treatment paid for.
What all? Let's just keep talking about the PIP policies, because I think that's very important. I think that a lot of people don't understand PIP.
Right.
They get very frustrated when we talk about no fault, and they're like, "Well, I wasn't at fault. Why is my insurance company paying? They're paying for my medical bills, but the other person was at fault. He was clearly at fault. He admitted he was at fault, but why am I paying? And is this going to affect my rates?" But oftentimes we think of PIP paying for medical payments, but there's also provisions where PIP will actually pay for
Lost
wages or mileage.
It can potentially pay for up to 60%
but there's only so much
lost
that goes
wages.
around, though.
Right, and here's the thing also, even just as a rudimentary practical matter, the person that caused the accident is not going to pay for your treatment as you go.
Right.
That's the difference between a PIP benefit. This works in effect like health insurance and pays. They bill the PIP and it gets paid, and you're getting that treatment paid for as you go. Conversely, a liability policy will only pay when you resolve the case.
And they try to pay one time.
They typically can only pay one time, and that can be frustrating for people because they're like, well, charge it to that other person's insurance, and unfortunately, that's just not the way liability insurance works. And so, typically, we're looking at a situation where I tell people a lot of times when I ask, well, what's the timing of when is this going to be resolved? And it seems a little counterintuitive, but a lot of times the amount of the insurance, because in most situations the only practical recourse is the amount of insurance somebody has, because most people do not have assets that you can go after.
Now, I tell you, you brought up a good point there. In the liability policies, typically in most situations, pay one time.
Yes.
They write one check, and that one check comes with a piece of paper called a release. Now, that's why it's very important, if you've been involved in an accident, do not talk to the insurance companies until you have spoken to someone who can actually advocate for you. And we would highly encourage you to call an attorney that specializes in personal injury practice, so they can at least advise you of what you're signing or what you're giving away, because we've had a lot of cases over the years that have come through our office where the insurance company can go to someone's house after an accident, knock on the door, offer them a lot of money right now.
What seems like
a lot of money, and I'm talking about $2,000 or $3,000, $500, whatever it may be, and that person accepts the money, they cash the check, and they sign what's called a release. And that release has forever forbidden them from actually pursuing any claim from there on out for any injuries that may or may not have. Now, what's tricky about that is insurance companies get to the individuals who have been involved in accidents and are injured very, very quickly.
Yes.
And we've seen over the years of our careers, injuries don't manifest themselves just like that. You have a lot of swelling after an accident, and a lot of the injuries don't show up in diagnostic testing because of the swelling. And it takes several weeks and sometimes even months for physicians to be able to diagnose someone properly and give them a prognosis. And so if you sign away all of your rights early on, thinking that you're okay because you have to get back to work, well, then it's really hard to help you. And there's been times we've had to give the bad news to individuals who actually have signed these releases, but yet our legislature doesn't think that that's wrong, and they allow insurance companies to do that.
Right, and another gotcha is a lot of times people don't understand that they're assuming that their health insurance will pick up all the bills and take care of it, but they don't realize that those health insurance companies have what's called a right of subrogation, which means they get to be reimbursed out of any settlement proceeds. And the insurance company gives you a check for $2,000, and then here comes Blue Cross Blue Shield saying, hey, John Smith, you owe me that money. And so they don't explain that to you, and then I've had to have that conversation with, unfortunately, that's what your health insurance contract says. And if you had come and sought advice beforehand, you could have had that information and made a proper decision, because you have to have the information to make an educated decision.
And real quickly, we have a caller on the line, but real quickly, it's free to talk to us.
Yes.
We work on a contingency fee basis, so you're free to call us, to talk to us, to ask us these questions. And if you don't want to hire us, well, guess what? You don't owe us a dime.
No.
But at least you know.
Right.